Welcome to QuidNunc's podcast. Today we will hear the story of a case that defines the balance between private property and public welfare. Imagine a city, Mumbai, India's financial capital, where towering old buildings tell stories of a bygone era. But with these stories come challenges: collapsing structures, safety hazards, and a government grappling with tough choices. This is the story of a property owner association versus state of Maharashtra, a legal battle that shaped the future of private property rights in India. So let's start at the very beginning. Our story starts in a Mumbai, a city of dreams and legacy. Back in the early 20th century, during the city's textile boom, thousands of workers migrated here, and in a rush, countless buildings were constructed. But decades later, these structures began to crumble. Over 16,000 buildings built before 1940 were still home to thousands of families despite being unsafe. The coastal climate and monsoon only made things worse. To tackle this, Maharashtra government passed MHADA Act 1976, aimed at restoring old properties. In 1986, Chapter 8A was added to this act, which allowing the government to acquire old buildings with the consent of 70% of tenants. The law claimed to follow Article 39 Clause B of the Constitution, which talks about using resources for the common good. But here's where the twist came. Property owners in Mumbai weren't convinced. They believed the law was unfair and took away their rights. Thus began a legal battle that would last decades. The battle begins owner versus the state. The Property Owner Association, representing over 20,000 landowners, challenged the law in court. Their argument was simple. First, the government had no right to forcibly acquire private property. Second, it violated their constitutional right under Article 14 and 19. The state of Maharashtra, on the other hand, argued that the law was a step towards public welfare. They claimed it was their duty under Article 39 Clause B to ensure resources benefited society at large. The Bombay High Court sided with the state, saying the government's move was justified. But the property owners weren't ready to give up. They took their fight to the Supreme Court. As the case reached the Supreme Court, the stakes grew higher. The central question was this: can private property be called a material resource of the community under Article 39 Clause B? To answer this, the court revisited history. Several past cases had debated this very issue. Among them, in Ranganath Reddy 1977 case, the majority said private property couldn't always be included as community resources. Justice Krishna Iyer, however, strongly disagreed, arguing that redistribution was essential for equality. Then came Sanjeev Kaur case in the year 1983, where the court leaned towards Justice Krishna Iyer's view, saying private property could serve the public good in certain cases. And finally, in Maftal Industries 1997 case, it upheld this interpretation, allowing private property to be classified as a community resource. But conflicting opinions left the matter unresolved. This case became the perfect stage to settle the debate once and for all. On 5th November 2024, the Supreme Court delivered its verdict in a 7:2 majority led by Chief Justice D.Y. Chandrachud. The court clarified that first, not all private properties is a community resource. Only those properties that directly serve public welfare, like forests, minerals, or wetlands, can be classified as such. Second, Article 39 Clause B requires context specific evaluation. The court ruled that each case must be assessed on factors like resource scarcity, community impact, and ecological importance. Third, past judgments were reconsidered. The court overruled the broader interpretation from Sanjeev Kaur case, calling it too expansive. Justice B. Nagaratna added a unique perspective. While agreeing with the majority, she reminded us not to judge past decisions harshly, as they were made in a different social economic era. Meanwhile, Justice Sudhanshu Dhulia dissented, arguing that earlier views promoting redistribution were still relevant in tackling equality today. So, this case isn't just about property, it's about balance. For property owners, the judgment ensures their rights are protected from arbitrary acquisition. For the state, it sets a clear framework for acquiring private resources only where public welfare truly demands it. In the end, this landmark case reminds us that law must evolve with society. While the constitutional directive principles aim for welfare, they must also respect the rights of individuals. And that, my friend, is how the tale of Mumbai's crumbling buildings sparked a debate on property rights and public good. For study notes of the case, you may see the link provided in the description box. Till then, stay informed, stay inspired.